For judgment, item number 33, supplementary list.
This is ours only. I don't know.
We accordingly set aside the conviction of the appellant under section 302 of IPC and convict him to undergo convict him under section 304 part 2 of the IPC and to sentence is 8 years.
I agree.
For judgment, criminal appeal, jail 15 of 19, along with death sentence reference 2 of 2019.
We uphold the conviction, but we are commuting the death sentence to imprison for life.
I agree.
Obliged.
May please, Your Lordship. For listing of a WBC, Your Lordship, pertaining to foreigners tribunal, Your Lordship. The whole family declared foreigner.
If you are a foreigner, then we declare foreigner. So what?
Any day before vacation, Your Lordship.
No, is it a fresh matter?
Fresh matter.
You file it fresh. When did you file?
13/12.
Huh?
13/12.
Next week.
Hello.
20.
Yes, Your Lordship. We filed this matter yesterday only. Matter will come up on Monday, my lord, because it was urgent.
What is the urgency?
She has been declared foreigner by the FT, so she's apprehending arrest anytime. She's under severe mental strain.
When she was declared a foreigner?
3 months back.
3 months back.
Lordship.
And she's not able to sleep. How old is she?
50 years.
50 years. Next week.
2012.
Next week.
Lordship.
May it please, Your Lordship. My lord, with the consent of the others, I beg to mention item 20 and 21, my lord.
What do you want?
I'll be taken up after the vacation, my lord.
On the prayer of Mr. Spencer.
Data.
2021.
Yes, ma'am.
After vacation. Yes. Next.
May it please, Your Lordship.
Yes.
I beg to mention item number 1.
Yes.
Is today's leave. My senior and Sarkar is out of station, my lord. So adjourn the matter for today, my lord.
What is this 2019?
Lordship, I told him that let the matter reach,
Ah.
maybe it can be fixed for hearing, and then I have not gone into it, Lordship. The LCR is also not there. So Lordship, he can just wait for his turn.
We are not superstitious, but then if the item number 1 is adjourned,
Yes.
it has a what do you call it? Kind of
It doesn't, it
It
can
is-
just wait. It is just 2 minutes.
because item number 1, it will be called out your
Yes,
first.
Lordship.
And you cannot wait. You have some urgent matter, some other code.
No, I did tell him, Lordship, you please wait. Don't mention it because it's item 1.
Because 1 means it will be called out first. Number 1.
Exactly, Lordship.
Number 1.
These things the seniors should have advised.
For item 1, because you are given the rare opportunity of your case being listed item number 1. Everybody wants item number 1, no? Early. And what can be earlier than item number 1? Of course, when we are young lawyers, we used to have before motion item. Have you heard this before
No,
motion?
Lordship.
There was some of the lawyers were so eager that matter be heard at the earliest. My lord, that be listed before motion. And we had the privilege, of course, as a lawyer, we also did. So we had the privilege of getting some of the items before motion.
And it was allowed, Lordship?
Was it? Yes. Yeah. That was in, say, 2019, not many. Yes, it was in, say, 2000, what? No, not even 2019, 90, you know, like 80, yes, 1918. In our High Court, that is why I didn't practice in Bombay High Court. I practiced in Guwahati High Court. So,
I missed it. I was there, but I never heard about it.
yes.
I have missed it.
Yes, we had this before motion. So it will come up very boldly before motion. So the proud lawyer will come in, argue before motion, get a stay order, walk out,
Wow.
and all the lawyers will look at him with awe and respect.
It's a
Huh?
privilege.
It's a privilege, no?
Yes, Lordship.
So item number 1, you will be called out. Nobody can stop you from mentioning or submitting at number 1. No? So let the matter come up.
It's courtesy also. The person, the lawyer
No,
mentioning.
these
should
are
also
part of
know.
the people we learn. I learn every day. At this stage also, I learn so many things from the members of the bar. Good things also, no? New things. So learning is always a process in life. Learning stops when we stop breathing. Till then you learn. Everything is new experience in life. Yes. Next mention.
Item number 24 may be added.
Okay, on the prayer, Mr. Spencer says.
Yes, that's on behalf of Jesse Google.
Yes. Next.
Publish.
Yes, item number 1.
Delhi,
Item number 1, yes, the privilege, yes. What is your name?
NM data.
What do you want?
So Lordship may kindly adjourn the matter for today.
What is this matter? Do you have any idea? That is the thing. You have brought your very precious file, which contains only the cause list. It doesn't contain anything else.
It's a contested matter, Lordship.
But then, who knows, it is such a good case, we would have allowed at the motion stage.
Yes,
Sometimes we do also, no?
yes, Lordship.
Even though Ms. Verma will vehemently oppose, but we sometimes, there's nothing in this, why keep this matter pending? So we allow also. Maybe, I don't know, maybe, so if it had been there, we could have allowed now. Item number 1. But you chose, because you don't know anything about the case. Okay, on the prayer of Mr.
NM data. On
The
behalf of
matter will be
myself
listed
and
on
so-
1st January is a holiday, no?
Yes.
Otherwise, we could have given 1st March, 1st February, you are number 1.
Lordship, I have this is a 2018 opinion.
19 matter.
No, opinion is of 18.
Oh,
So Lordship may issue notice and call for the records.
what is your name?
NM data.
And Mr. NM Degar, Lane Counsel for the petitioner. Issue notice, her also issue notice, issue notice, What about interim? He will get?
Lordship, he has to pay for
Yes,
it.
yes.
Interim may be continued.
See. Now he wanted adjournment, now he saw this opportunity, interim. Because he found that the government council is not going to oppose seriously. But then that's why I'm saying, no. See, court is something, it's a life, real life. See, this is not some interview where we ask some theoretical question, hypothetical questions, what is this, if somebody does this or this is a real life. This Abdul Ali, when he hears that he has been given this interim relief, he is going to thank you. Where does he stay, this Abdul Ali?
Kamrup, Lordship.
Huh?
It's of Kamrup Rural.
Kamrup Rural, somewhere near Brahmaputra Bank.
Nearby, he's in Kamrup district.
If it is near Brahmaputra Bank, he will bring you a lot of arimas for you, big arimas. Interim. Police, when the police come, he will go back after seeing this interim order. The police sent by Mr. Sharma and Verma, they will go back empty-handed. Okay, notice record interim.
item number 2,
Gautam Pal.
LCR has come, alert.
LCR
has come, alert.
LCR come. Okay. Notice, since the records have been received, the list the matter for hearing on sense.
item number 3,
Same, I think, item number 3.
Same lordship,
Since,
no, LCR is there,
LCR is there.
maybe fixed for hearing lordship.
Since the records have been received, the matter be listed for hearing.
Item number 4,
May I please, your lord.
Yes.
LCR was called for worship after when
Hmm.
LCR received lordship.
Okay, since the records have been received, let the matter be listed for hearing.
Obliged.
item number 5 and 6,
Polymol,
May I please, your lord.
polymol, yes.
My lord. There are 3 cases
Hmm.
against the, my lord, said family, my lord.
Hmm.
One is against the husband, one is against the wife, and against the whole family, my lord.
Oh,
Containing 2 daughters, my lord.
okay. But is it in the same tribunal or different tribunals?
Same tribunal, my lord.
Tribunal.
Ex-parte order has been passed, my lord.
Okay.
My lord, that ex-parte order, my lord, in item number 5,
Hmm.
item number 5,
6-2.
ex-parte order page 58.
Yes.
This is, my lord, order against FT case number 1055/2007.
Yes.
And another next page, my lord, 59, page 59.
Yes.
This is the FT case number 9/2007.
Yes.
This is also ex-parte order against, my lord, the family members,
Yes.
husband, wife, and 2 daughters, my lord.
Okay.
Both the ex-parte order was, my lord, challenged before this honorable court. And this honorable court was pleased to, with the dispose of the matter with the direction to file an application before the concerned FT Furnace Tribunal for setting aside the ex-parte order. Accordingly, they have filed application that was rejected, my lord. Ultimately, my lord, this writ petition has been filed.
No, this order was passed by the court, High
Yes.
Court on 11/4/2013.
My lord,
That
That-
this is ex-parte,
ex-parte,
allowing the petition approach for setting as an ex-parte opinion.
my lord.
Then what happened? Then what is the opinion of the tribunal?
Tribunal, my lord, rejected
Where is that order?
that order, my lord, kindly see page 74.
24.
Relevant portion, page 75.
When the order was passed?
That was, order was passed, my lord, 7/3/2013.
9 years, after 9 years you're coming.
No, my lord, that is in the meantime, my lord,
Hmm.
that was challenged before the High Court. My lord, kindly see page 60.
Page 60.
60.
This 2013 also challenged.
Yes.
Okay. Page 60.
No, my lord, no,
Page
I'm sorry,
60.
my lord. That was challenged in this writ petition. Rejection order challenged in this writ petition.
Which writ petition?
4298,
Next one.
2019.
4298, filed in 2019.
My lord,
That means, uh,
36 years, after 6 years.
after 6 years.
My lord. There,
Then,
my lord,
and you woke up after 3 years, 4 years.
my lord.
You yourself woke up the 4 years. After filing the writ petition 2019, you forgot
My
about
lord.
this writ petition.
My lord, that was, my lord,
COVID.
COVID started much later, lordship.
See, I knew that Verma would say COVID was in 20, not in 19.
Exactly,
lord.
lordship. And this was filed
2021,
early.
my lord, gone.
Huh?
2021 gone to COVID.
Correct.
22.
21 gone, now 22. Then what did you do?
My
Yes.
lord,
What did you do? You are also, you lost your file maybe. Verma, it happens also in our case also. As a lawyer, sometimes we, cleaning our chamber, and some junior who doesn't know or some clerk who doesn't know, he keeps in the dispose section. Then we thought that is disposed. Then suddenly one fine morning, the client rings up, what has happened to my case? I have given you so much money. I have nothing got any. You got? He'll check how much he gave me last time. Check my diary. I say, okay, I received so much, but I don't know what order I passed. Find out the file. File. And suddenly, oh, the file is lying in the section. And then go and mention in the court. And the judge also, okay. You want that? See,
Lordship,
what
my,
you-
My lord, petitioner-
submission would be. Lordship would issue notice, call for the records and examine this matter.
Okay.
my lord, that means otherwise, my lord, this
No, not-
ex-parte
not
order
in
may
this
be
case,
set aside,
lordship.
giving, my lord, I have the documents since 1965. 65 onwards, I have,
What is the
The
document
document.
60, what 65 document shows?
my lord, 65 documents is page 23, my lord, 20 to 23.
Page 20,
20, 23, my lord.
page
This
23,
is the voter list.
23. 23.
In the name of the petitioner's father, my lord, 23.
Nokol, see, what Nokol? What is the name of the
Nivaran Sarkar, my lord, Nivaran Namor Sarkar, is it?
Sarkar? Nahi?
Sarkar.
Is it Nivaran? Okay, Nivaran Nom Sarkar. Nomchor?
Namor Sarkar, actually Sarkar, my lord, this is the Namo is a spelling mistake here. Sarkar, Nivaran Sarkar.
So Nivaran Namo Sarkar.
My lord. And page 20, my lord, page 21.
And these
1970.
family members, two daughters, how old are they?
My lord, one is to 26, 25 years, one, my
And
lord, 24 years, and one is 24 years.
And another,
Uma.
another,
Another 22 years.
have they been married?
My lord, in the meantime, yes.
Married?
My lord, this is the age of 2019, my lord.
They have been married?
My lord.
You're
No,
lucky.
that they are not married.
See, Burma,
Yes.
They are not
they
married.
can see the moment people come over there, declare foreigners, all these groom party will go back. They will break the engagement. Hey, suppose engagement ring ceremony, the boys party comes, that is a very good girl, very nice girl. And somebody does a trick. Hey, how can you marry her? She's a foreigner. Declare a foreigner. Immediately they will break the ring ceremony. Arey Baba, how can I marry to a foreigner?
Rejected foreign lodge.
Huh? Two
Rejected
girls.
foreigner law.
Male to no problem. They can manage. But girls, very difficult. Yes, what to do, Verma?
Lordship,
Let
my
them go back
submission-
satisfied. At least they
My
can
lord.
have a good marriage. Otherwise, they will not be able to marry.
Decision of this honorable court, my lord, ex-parte order.
These are jurisdiction where not only legal issues, but then other social issues have come up. That is the most, I found the most difficult jurisdiction. I can handle the most complicated of the taxation laws. But sometimes
Lordship, he
these
did
foreigners
appear,
travel.
he did appear after the ex-parte order also, filed a miss case, that was also.
But then
rejected.
the father is, but then girls, they are not, they're cooking, they're helping their parents. They don't know, they're thinking, these two girls are thinking my father is doing, and the father doesn't know how to
How
do.
can there be two ex-parte orders now? Why he
That
did
is
not
what-
appear in the first place itself? He knew about the proceeding. He has been avoiding appearing before the court. This kind of.
They're poor
behavior
people,
is
my
not
lord,
done, Lordship.
they are also suffering.
He's suffering
But it's-
because of his own mistake.
And I have stated, my lord,
Had
kindly see my
he-
application.
Had he, had the procedure.
Kindly see my application, my lord,
Got the notice.
what was submitted before the landed tribunal. That application, my lord, at page 67.
He is aware of the proceedings right from the beginning, Lordship. Why has he not appeared? What is, he has to prove that he is an Indian citizen. He cannot
Lord,
just.
I may submit your lordship's judgment, my lord,
This
dated
kind of submission.
2021,
97.
2022, 1 GLT, my lord.
97.
Same, similarly, I am similarly situated, my lord.
He is aware of the proceeding maybe much before he started his family also. He has dragged his family into this problem himself, Lordship.
And you had three lawyers, Bipul Sarkar,
So,
Dilip Medhi, Mujibur Rahman.
And he's not participating, he's not cooperating with the proceedings, Lordship. Lordship will,
My lord-
Lordship,
My
my
lord,
submission.
this is
would
an
still be
ex-parte
the
order,
same.
my lord. I may be given an opportunity, my lord. I have the, so
He
on
had-
65 onwards, I have documents, my lord.
His Lordship, he had opportunities from 97. And now again, he's asking for an opportunity.
Yes, in so many
Lordship will call
cases,
for
my
the
lord.
records, Lordship.
But why
let-
didn't you
let this
go?
go.
That is what, because the tribunal has passed
lord.
objection. Now you did not go, appear, file it in response, appeared
My lord.
on so and so, which is and third time, but
In the second-
thereafter OP remain absent.
Lordship.
That
till
the
today.
My lord, I have explained the delay, my lord.
Lordship, my friend
Kindly
is
see,
saying,
my lord,
is
uh,
not coming
page,
with
page
the
63, page 63, my lord.
Yes, it is.
That application submitted before the Foreigners Tribunal, my lord, for setting aside the ex-parte order.
In the second writ petition, Lordship, he has contested the matter.
Yes, in the second case I have contested.
Only thing is that, Verma,
Yes,
so
Lordship.
we are more concerned with this order on passed by the learned tribunal rejecting to set aside the ex-parte tribunal.
That-
What is the ground given?
Lordship, in which
Now,
item?
page 74 and page 75. That is the order he is challenging.
He's challenging two writ petitions together. Let him come one by one.
Petition.
Either he takes up item 4 first or 5, but he cannot club both these cases together, Lordship.
Hmm.
In one, he has contested and one is an ex parte order.
No. Both the ex-parte orders he have challenged and
No,
another
both are
contested
ex
matter
parte
I have
orders,
challenged in
Lordship.
item number 6, my lord. Item
No,
number 6.
in which case? You see,
Item number 6 was contested, the wife. That is item number 6, my lord.
wife
She is
contested.
also a party here in the
Wife contested, husband didn't contest. What?
husband, my lord, husband is declared ex parte in this petition I have
Okay,
challenged.
okay.
And the wife declared ex parte as well as in the contested case, my lord, that is item number 6. This separate petition.
No,
Lordship, the
but no,
first
no.
writ petition.
In
Lordship,
Porimal
we'll take it up
Sarkar,
one by one.
item number 5,
Yes.
in item number 5, you are challenging order dated 3/7/2013.
My lord, there are two cases.
Oh, let us go by one then.
My, yes.
Lordship, this clubbing of
My lord.
cases creates a lot of
You
confusion.
are
No,
dealing,
no confusing at all, my lord.
you are dealing with a very ordinary judge. Let me understand. Let us understand.
my lord.
5. One, no, item number 1, this item number 5.
Five,
Item number
Lordship.
Yes.
In item number 5, you are challenging the order dated 3/7/2013. Is it it?
I have challenged two orders, my lord.
Which one? Which are the orders you are challenging?
That is order dated, my lord. Annexure, my lord.
Yes,
annexure page, annexure 31, my lord.
yes,
Annexure 31, page 71. This is one order
okay,
passed in one FT case number 1055/2007.
okay.
That is order dated 1/7/2005.
1055.
Yes.
Then another
Then
is,
another order, that is, my lord, page 74. Miss case number 6/2007. That order was passed in FT case number 9/2007.
9/2007.
My lord.
Yes. And in this FT case number 1055, you are declared your husband.
Husband.
Okay.
Husband.
Now, what does the tribunal say by refusing to set aside ex parte? That is what we are concerned. We are not, in this case, Verma, we are not going to set aside the original ex parte.
My lord.
We are going to consider, because he went to the court and the court said, you go and approach the tribunal and make an application for setting aside the ex parte order.
Exactly, Lordship.
Then the tribunal say, no, we cannot do because they don't have the power or something like that.
No, Lordship, he did not file his WS. He was given a chance, Lordship.
No.
71.
No, please come to page 71.
71.
The
Second
learned
paragraph.
assistant government so-and-so applying his sum is written. A result, this expression so decline so-and-so illegally. If the agreement is not vacated, then it will suffer. The learned so-and-so applying for submit that written on the ground among the since the petition not been filed in proper is liable to dismiss. Written submit means objection to the application to set aside the ex parte order, not about the tribunal proceeding. The vexatious petition has been filed by petition for illegal gain as the grounds are not based on fact. No sufficient reason for default has been assigned. Since ex parte was a pass for negligence, the petition is liable to dismiss. Fine. None of the parties adduce any evidence. Although as per law, petition is required to adduce evidence in order to prove sufficient grounds shown in the petition. I have carefully or so-and-so the so-and-so ex parte did not. The OP appeared with his counsel engaged for so-and-so. According to the opportunity was given. So on the other hand, due to negligence, the learned counsel withdrew unable to submit document. It appears from the records that OP was quite negligent in the original case. As per provisional rule, Santos petitions to satisfy the court for absence, but in this case, no such documents or evidence have been produced. The medical certificate submitted along with petition shows that the petition was under treatment of doctor from so-and-so, but no medicals have been produced by the petitioner. The illiteracy and ignorance cannot be good ground for setting as an ex-parte order, as there is no provision for law. As there is no special provision for law for illiterate and ignorant persons. The learned AGP submits that although almost Supreme Court Director Foreigners tribunal to entertain petition proceedings, it is direct to set aside in accordance with law. In view of the tribunal is not such OP was prevented by that from hand I knowledge is rejected. Cost also. How much cost? 500. The certified copy of the constitution. So the learned tribunal held that since you could not show reasons why you remain absent.
He never produced any documents also. He was given all the opportunity.
To show that you are not able to, you could not appear for this reason. That's what the tribunal appears to say so.
My lord, kindly see my application, my lord. Application date to page 67. My lord, my application may be.
Let him a second chance.
Lordship may allow, but with a cost of 5,000 each on both the petitions. Because he cannot take this court for granted. Judicial time is wasted in the tribunal also, here also, Lordship.
How much cost?
My lord,
How much cost?
my lord. Your lordship, these the poor people, my lord. I have
Cannot
kindly
be
see my
poor,
annex of
Lordship.
page 63, my
Here,
lord, page 63.
Here he cannot be poor, Lordship.
500, my lord. Lower court also, Lord Tribunal also private imposed 500, 500, 1,000 cost they imposed already.
But the time will be fixed to file the written
My lord.
statement.
My lord. My lord,
Within that specific
my lord, my
time.
lord. I am ready to file them.
And no more adjournments. Lordship will specifically mention that. Lordship's orders are being honored in the tribunal, but if the proceeding goes on like this, it becomes, they are also.
No, time limit may be given, my lord. I within
Binded
the
by time, Lordship.
documents are ready, my lord. I may be given. an
97 to
opportunity.
2022 to get all the documents ready. And now he's not willing to pay the fine also, and he's putting all the blame on the tribunal. And so many
But what will
opportunities were
happen to the
granted to him.
contested?
My lord.
There is a one is contested. What will happen to the contest?
My lord, that was, my lord, I have produced the documents and in that case, my lord, the London Tribunal held that there is no linkage. Petitioner failed to
Tribunal
prove
take
the
a call
linkage.
on Whatever.
But kindly
documents
see,
he's
my
going
lord.
to submit, Lordship, my submission would be, he can produce all the relevant documents at the tribunal. Tribunal will take a call on that, Lordship.
And in item number 6, what was the order passed by the tribunal?
That order, my lord, at page,
It is at page 33,
33.
Lordship.
and the last order, my lord, kindly say no linkage. It is the linkage is not proved. My lord, what happened? I have submitted a 1993 voter list, certified copy of the voter list. That kindly say, my lord, that voter list is annexed here, 21, page 21, annexure 4. That was the disbelief, my lord. Not admissible saying. This is a certified copy. And a certified copy did not be approved, my lord. This is a certified copy. My father's name is there, my mother's name is there, and my name is there. So it proves itself proves the linkage with my parents. And the not only petitioner, the whole family declared by this petitioner, allegation against the petitioner, but the whole family was declared foreigner in this by this judgment.
Lordship, I have a submission, Lordship.
This is also an illegal. Prima facie illegal order. My father, my lord, I have given voter list 1970, NRC 1970, voter list of 1971, then the linkage, my lord, 1993, along with my parents. Land document, my lord.
Lordship, I have a submission. Lordship will look into his petition, annexure 36, he's relying on annexure 11 also, which is the notification by the government of India regarding people who came from Bangladesh or East Pakistan. He cannot take
Please,
both
please.
the views.
Please,
uh,
please.
Page 36, annexure 11. My friend cannot take two views together. One, he is producing all Indian documents saying that he's an Indian citizen. And secondly, he's even asking for relief under this notification. He cannot have options. If plan A doesn't work, plan B will work. He has to go with one, Lordship. Either he says he's an Indian citizen and he proves that, or he says I'm a Bangladeshi citizen and he takes protection from this notification.
On the basis of documents, my lord, since 1970, I have produced the documents.
Lordship, in most of the cases.
Abandoned
Lordship has also noticed-
question, my lord, that is.
In most of the cases, Lordship has also noticed both the things are there in the petition. They keep denying that they are not from Bangladesh, but they want protection under this notification. Which one does he want, Lordship? He has to decide.
Okay,
he
you
cannot
go and
make-
decide in the meantime, you decide, go to tribunal. Take a firm decision.
One way, Lordship, not
My lord,
not
17
that way and the highway also.
Because when the highway is split into two, no, you have to decide which one to go. You can't go both, travel the both.
He says either my way or the highway.
My lord,
Okay.
that is not the question, my lord, but I have produced the documents, my
Because-
lord.
And Mr.
PCD.
PC, the Land Council for the petitioner in
Lordship
this
will not forget the cost.
cost. He says 500, you say 5,000.
Lordship will bring it to 5,000 for both the petitions.
5,000.
My lord, is it a fit case, my lord, to impose cost, my lord? Can't we consider, my lord? Overall situation, my lord, overall situation.
Yes, Mr. Day, 2013 to 2019, it's an absolute.
My lord, I have given explanation, kindly see.
No.
What are you
Then-
doing? What is your profession?
My lord, he is the cultivator, my lord. He's a laborer, my lord.
No,
Tea
no,
garden labor, my
cultivator.
lord. He's a-
He owns his proper land also?
No, my lord.
Huh? How do you say, what is it? Let us see your
Well, kindly see, my lord, that is paragraph
paragraph.
in my lord. In the item number 5, my lord.
Number 5, yes.
5,
5, yes, para number,
paragraph 24, my lord.
para 24.
My lord. Paragraph 24, page 15, my lord. Last, bottom, my lord, page.
Very poor, but what is your profession? Have you mentioned anywhere?
My lord, he is working in the tea garden, my
Where
lord.
is it?
That is,
First he said.
my
he's
lord,
a
page
cultivator.
22, paragraph 22, my lord.
Paragraph 22.
22. The last portion, my lord, last portion. The petition number 2 also illiterate, still at the fag end of his life. The petition number 1 has to earn his livelihood as a daily laborer, serving in Gopal Krishna Tea Estate, Morigaon.
Where is it? Where is it? Para number?
Para number 24, last 3 lines,
24.
my lord. last
24. 24.
22,
22.
page 14. plus 3 lines, my lord.
Yes, Madam Burma,
Yes.
500,
Make it 1,000.
500 each one.
Yes, Lordship.
And Mr. PC Day,
PC day.
Plenary Council for the petitioners. In WPC, huh? Item number 5, huh? 4298. In this petition, the petitioner. 8 bigha. Oh, you are landed by 8 bigha. Page
8 bigha.
Page 55.
Page. Doyal Mondal.
8 bighas, 2 kathas, 5 lessons.
8 bigha, I don't know how big is this.
This is in the name of grandfather, my lord.
Huh?
So he has 50
My lord.
has almost. 40,
This is against the
41 kathas.
grandfather's name. This land was in the grandfather's
The
name.
grandfather doesn't enjoy
Well,
that anymore. He's enjoying
petition-
something else.
Now petition.
Grandfather does not enjoy.
Now the grandfather.
You are enjoying the grandfather's property. Or is it, or you have been given to your daughters? No?
Situation, my lord,
Huh?
doesn't,
Oh, PAN card also there. Daughters are studying.
everything is there, my lord. These are the requirements of the daily lives, my lord.
Much more literate than any of these people
Is it-
living in the.
Without PAN card,
City's
my lord.
lordship.
Open the account. His
Lordship, if you
position,
don't
my
need to
lord,
look at
latest
that
position is
synopsis,
very.
Both the petitions are so contradictory that I just wish Lordship would notice and ask if, get the records here.
Now these daughters are getting educated. They will advise the parents. These parents are illiterate. They don't know. You tell your daughters to advise you after getting education. Okay, Nico, as the present this petition, the petitioners have challenged the page number 70. The order dated.
Pass, Lordship would pass two separate
orders,
orders
my lord.
because one is a ex parte and one is contested.
Yes, yes.
Two separate
Ex
orders.
parte
would be
order,
passed,
my lord.
Lordship.
Two orders, page 58 and 59. Main piece in the main FT case. FTD case number 1055/2000.
It is, the petition have challenged the order, ex parte order dated 19/4/2012, passed by the Lanet Foreigners Tribunal First Morigaon in FT case number 1055/2007, by which the petitioner Sri Porimol Sarkar was declared to be a foreigner of post 25/3/1971, comma. The ex parte order dated 14/6/2012 passed by the Lanet Foreign Tribunal First Morigaon in FT case number 9/2007, by which the petitioner Porimol Sarkar, comma, his wife Subhasini Sarkar, page 59, Sarkar, comma, Sumu Sarkar, son Sumu Sarkar and daughter. Oh, one son and one daughter, not daughters.
No, my lord, Sumu Sarkar is the wrongly written bracket. She is also daughter, my lord.
She also daughter.
Yes,
Are you sure?
yes, my lord.
And the children. And the children, namely Sumu Sarkar and the Ruma Sarkar, have been declared to be foreigners who had entered India, Assam after 25/3/1971. Full stop. The petitioners also have challenged the subsequent orders passed by the Lanet Foreigners Tribunal in the aforesaid Ruma, Suma and the Ruma. The petition also have challenged the orders passed by the Lanet Foreign Tribunal in the aforesaid proceedings, by which the application for setting aside the ex parte orders in terms of the direction of this court passed in direction of this court in page number.
Page 60, my lord, in
Huh?
page 60.
Oh. Yes, passed by this court in WPC number 433 of 2013 on 11/4/2013 and
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 WPC number.
WPC number 525 of 2013 on 31/5/2013
13.
were rejected. In miss case number 02 of 2013, while order dated 1/7/2013 and what is the other one?
My lord, that was the
and
High
in
Court
miss
order.
case number 06 of 2013, page 74. In miss case 002 is 71, page 71. And in miss case number 06 2013, while order dated 3/7/2013 on the ground that no case has been made out for setting aside the ex-parte order. Thus, in this petition, 4 orders are challenged. Number 1, 2 orders passed by the foreigners tribunal, 2 ex-parte orders passed by the foreigner tribunal declaring the petitioners to be foreigners. And number 2, 2 orders passed by the foreigners tribunal rejecting the plea of the petitioners to set aside the ex-parte orders.
Well.
Coming to the rejection of the application for coming to the efforts, Mr. Narak, counsel for the petitioners submits that the passing of the ex-parte orders by the learned foreigner tribunals in the 2 proceedings, that is 2 proceedings, that is proceedings, that is order dated 19/4/2012 in FTC case number 1055 and order dated 14/6/2012 in FT case number 9 of 2007 by the foreigners tribunal first Morigaon, where due to why you couldn't go this first time ex-parte, why?
My lord, petitioner being a poor person, my lord, he could not collect the documents in
As the
time-
petitioner
in time,
could not
and there is a
collect the
communication.
documents necessary connect.
Objection here. He has documents of 5363 he is showing, and he could not produce it at that right time in the tribunal. And he's asking for quashing of that. Lordship, my submission is that Lordship would just record, he was given sufficient opportunity.
We'll do that, we'll do it. We'll record your submission.
And he cannot say that poor person, he's playing this poor person card all the time.
Yes, he is a poor person.
It
It is
does-
not-
A poor person having 8 bighas of land.
Yes, Lordship.
Then I'll be the poorest. I don't have any bigha, even 1 bigha also. I'll be poorer than these poor persons. I don't have a 1 bigha also. I have a small house.
Enough opportunity was given to him, Lordship.
Because they could not file the documents in time.
There is a communication gap between the advocates. and-
Now communication gap is okay then?
Yes, it is in the mentioned in the petition, my lord.
Getting all his.
My lord,
submissions
my
recorded.
lord,
My submission-
All the
We'll
things,
be recording, we'll record your.
all the things on the basis of pleadings I am submitting, my lord. Not without the
communication,
pleadings.
because of communication gap and also is ailment.
Elements, yeah.
Communication gap, it is engaged counsel before the tribunal and also his ailment.
My lord.
And though the petitioner had appeared on earlier occasion and also filed written statement, full stop. Under circumstances, it has been submitted that that the failure to appear for tribunal was not deliberate, but due to reasons which were beyond his control at the relevant time, full stop. Though Ms. Verma has argued that these are all excuses invented subsequently to make up their negligence in pursuing their proceedings in much as they ought to be alert and collect the relevant documents in time and file the same. And such practice may not be encouraged. And such explanation may not be accepted. Accepted without heavy cost in this regard. In as much as they were negligent, and they have to be blamed themselves for the situation they found themselves in. And no blame can be put on the tribunal or the state. Next paragraph. We have also gone through the orders passed by the tribunal as well as passed by the tribunals mentioned above. Though this code gave a direction, this code gave directions on 11/4/2013 in WPC number 443 of 2013 and the 31/5/2013 in WPC number 525 of 2013. We approached the tribunal for setting aside. The tribunal, by orders dated 1/7/2013 in Miss case number 0 of 2013 and an order dated 3/7/2013 in Miss case number 03/06/2013 rejected the said applications on the ground that the petitioners have not been able to provide sufficient reasons and grounds which prevented them from appearing before tribunal, and as such, the ex-parte orders could not be recalled. We have noted that from the impugned orders, what can be noted is that the petitioners were given sufficient time for filing written statement and documents to contest a claim, yet they could not do so, resulting in the passing of the ex-parte order as well as passing the ex-parte orders. Coming to the subsequent miscellaneous cases, the tribunal held that since the petitioners could not provide sufficient documents proving their illness and other difficulties, they could not assign sufficient cause for recording the ex-parte order. While the orders of the learned tribunal does not appear to be illegal in any case, these orders were based on what the tribunal felt based on the materials which was placed before it, yet we have the view that since this matter concerns the citizenship of the petitioners, which is at the root of all other rights which they may enjoy in this country, perhaps we may allow the petitioners to approach the tribunal again to prove that they are Indian citizens. We do so for the reason that in the present petition, the petitioners have relied on a document, certain documents, including, what is that oldest document?
1965 voter list, my lord. Page 23.
Voter list of 1965, in which the name of one Nibaron Nam Sarkar, Nomo Sarkar, as a son of Manmohan, is shown. And who is this Poyotmani?
Poyotmani, my lord, is the mother of the petitioner. This
Nibaron is the father.
Nibaron is the father, and Poyotmani is
and
the
one
mother.
Poyotmani also shown.
Porosmani, excellent.
Porosmani.
Yes.
Porosmani are shown in respect of what gaon? What gaon? Sat. Mauja Moyong. Sat Khapori Dolni. Khapori Dolni. What is the name of the village?
Village, my lord. Shatkhapani Dolni.
Sat Khapori Dolni. Sat Khapuri Doloni in Nagaon district under
Morigaon district. Now
Nagaon.
Morigaon, earlier it was.
Now this deed in Nagaon district under 83 number Legislative Assembly Constituency LAC. It has been submitted that the said Nivaron Nam Sarkar is the father of the petitioner number 1, Sri. What is the petitioner number 1?
Porimal.
Porimol Sarkar. It has been also submitted that the said Nivaran, you came to India from Bangladesh, or what is your case? You tell us. Or you are original Indian
My lord, his father came before partition, my lord.
before partition.
Partition. There was 46, 40. There is
They have been submitted that the said the said Nivaran Nam Sarkar, Nomo Sarkar had entered India from Bangladesh much earlier during what?
My lord,
We are
Where was
taking
he
this.
born, Lordship? Where was he born? How did he get into India? He has to explain that. And this project.
They had come from to India by seeking refuge in this country.
And
full
where is
stop.
the refugee certificate of the father then?
Be it as it may, if the petitioners are tracing their ancestry through the said Nivaran Nam Sarkar, whose name is shown as a voter in the 1965 voter list, electoral list, and if the petitioners are able to prove the linkage with the said Nivaran Nam Sarkar, they would have a legitimate, they can make a legitimate claim before a tribunal that they are also Indians. Under a peculiar circumstances, we have the view that under peculiar circumstances as mentioned above, this court, without going into the evidences which have been relied on, would direct the petitioners to approach the tribunal with all these documents to show that they are Indians, not foreigners. Accordingly, we are inclined to recall this order. Accordingly, we are inclined to recall the orders. We are inclined to allow this petition by setting aside these 4 orders, 1, 2, 3, 4, so as to enable the petitioners to appear before a tribunal to prove that they are Indians, not foreigners. Your forefathers, you are not also coming. You are saying page 6, forefathers of the petitioner had been living for a long time in Morigaon. Forefathers. And in Likho that the forefathers of the petitioner have been living in India for a long time.
Lordship, 1 second, Lordship. Sorry for
Yes.
interrupting. Since Lordship is mentioning his father's
Nam Saran, something
Nam
else. Nivaran.
Just come to page 39 of the NHA 11, item 5, Lordship.
Page 39.
And now Lordship will please come to page 22.
Page 22, yes.
This is the voters list my friend is
Nivaran.
relying on. And this gentleman is in the year 1965, his age is 53. His projected father, Lordship. And in the PAN, Lordship will see his date of birth is 1958.
50 of Porimol.
Not of Pori.
Porimol.
Porimal. Now
Porimal.
petitioner is Porimal.
Porimol. Petition is Porimol.
He is the father of the
Income tax.
Nivaran is the father of the Porimal.
No, what I'm trying to show is the names are also do not match anywhere.
Why?
There is a discrepancy.
There is
This
a Nivaran.
Nam
I am told by my brother that they write Nomo Sarkar, they write add Nomo if they belong to certain SC community. That is why.
SC community.
But then
So
it
like-
is not reflected.
SC certificate is also there, my lord.
They said maybe
Valid.
they don't want to
SC
show it.
certificate is there.
This matter would have.
Maybe
really
now,
taken a long
see,
hearing.
this scheduled caste or this caste is something very sensitive. Some people want to maybe don't want to show it. They said, okay, I am no more. I am Sarkar. Earlier, no more Sarkar. So they said, we have problem ho pare. Here all kind of problem. No more Sudro. So I said, no more Sarkar. So they said, I want to will jettison.
And
Will jettison no more.
It happens.
No more is otherwise supposed to be, see, when you start any invocation, if you are Hindu, Nama, Nama, you know. But then they want to jettison it because they think that, well, it may create social problem, whatever it is. So there's a very delicate area, sensitive area. We do not want to make any further, comment. Sometimes it is taken, may not be maybe misunderstood. It was very delicate.
Today's
So let them explain before a tribunal why it is no more, why it is no more, why they left no more.
instead of lordship going into each document.
So we will not go.
my
Therefore, we just
suggestion
mentioned
is-
that only 1965 were referred so that
And
they-
let the
this is the-
tribunal decide.
let
lordship.
the term,
Yes,
of course, that is what we are going to. We are not going to declare them Indian Burma. No. That tribunal will decide. Of course, he is an income tax payee. You are income tax payee.
Let him
I am.
prove how he got to India, then he.
Because he has because otherwise,
He's a poor
PAN
cultivator
card.
lordship. He's a poor cultivator.
But he has to pay this revenue tax also, no? Khazana to dibo lagibo. For the 8 bigha.
Lordship, 500 cost was imposed by the tribunal, and lordship is also.
Will increase to 500.
Because if-
500 plus 500, 1000.
No, tribunal had imposed 500 for both.
Both. So for
No,
both, will
individual
increase to
part.
100%.
It has. to be more
100% of
lordship
500 would
because
be how much?
it would be
100% of 500 will be 1000. So we'll impose 100%
1,000
cost
of
more.
lordship.
100% more cost to you.
Because if he could pay then 500, today he can pay maybe more, but we are still being very liberal and asking only for 1,000.
where from you
1000.
submitting my lord?
लिखो last sentence क्या था? Last sentence.
Lordship, accordingly, we are inclined to allow this petition by setting aside
Allow the petitioners to approach before the tribunal to prove that they are Indians, not foreigners, for which they may file a written statement and also the documents on which they rely and adduce evidence. However, considering that they have come belatedly a cost of rupees 1,000 each is imposed on the petitioners, 1,000 each. Okay. Yes, anything else?
And Lord, he will fix a date. and
Okay,
we'll file
the petitioners
WS
will
on the
appear,
first date.
the petitioners will appear before the tribunal. When will you appear? Give a date. On 1 month? Okay, we'll appear before the tribunal within the period of 1 month from
Lord,
that.
Fix a date, Lordship,
Okay, give a date when you will go.
9th of January. He has all the documents.
After
He'll
1
file his
month.
WS.
After 1
After
month will
be-
be
after
15. After Bihu.
after we
17th, Lordship.
Bihu, after Bihu. What is
After
the
Bihu.
Bihu?
my lord.
17th of Jan.
17, because if they eat something more, then they may have problems. See, they are
23rd, Lordship.
23rd, okay. If
23rd.
they consume, see, Bihu
More than
time,
a
that
month, Lordship.
23rd is okay.
And he'll file his
Without fail.
WS on that date.
23rd, my lord.
23rd.
My lord.
Okay. They shall appear before the tribunal on 23rd of January. Without fail.
My lord.
And the cost to be deposited in the Legal Service Authority of Morigaon.
In the High Court.
Okay, High Court. You deposit in High Court.
My lord.
Legal High Court.
Lordship has not mentioned he'll file his WS on 23rd, Lordship.
Okay. And appear and file the written statement also. Appear on 23rd and also file the written statement.
Statement.
Written statement. And subject to payment of cost of rupees 1,000, 1,000 each as mentioned above before the Assam State Legal
State
Service
Legal
Authorities. Okay. In Goa, Assam State Legal Service Authority. Let's go.
This order was passed in item 5.
5. And 6.
6 is the contested matter. Lordship, they will
Contested
appear
matter.
there on the same date and
Likho in WPC 4301 The petitioner Subhasini Sarkar is one of the
We
petitioners.
consider
Ah,
this an
Is the
application.
petitioner number 2 in WPC number 429 of 2019, in which we have already allowed the petition by directing the petitioners therein, including the present petitioner Subhasini Sarkar in WPC number 4301-2019 to appear for the tribunal for filing written statement and the documents. Under the circumstances, we have the view that if the present order, impugn order remains in the upper stop. We also have, in the present case, we also have noted that while the learned tribunal have given certain reasons for declaring the petitioner Subhasini Sarkar as foreigner, we have noted that the learned tribunal has not considered the significance and relevance of the 1970 voter list of her parents, which was exhibited Exhibit A. Full stop. In our view, since the petitioner was tracing her ancestry linkage to her parents whose names were included in the 1970 voters list, this voter list will be highly relevant and critical for determination of the citizenship of the petitioner. Since the learned tribunal has not considered, page 34, para 5.1, they have not considered. Though the learned tribunal has merely mentioned the said Exhibit A, the tribunal has not given any consideration by way of relevancy or reliability or credibility of the said documents, which is required to be undertaken by the tribunal while giving its opinion. Under the circumstances, we are of the opinion that the tribunal will be required to pass a fresh opinion, full stop, for which and accordingly fresh opinion, and accordingly impugn order dated 29/3/2018 passed in FT case number 295/2019 is set aside. The learned tribunal will accordingly pass a fresh opinion after hearing the petitioner in accordance with law. This is the petition accordingly stands allowed. 6. Next.
Item number 7.
Is mentioning the cost here.
Sorry. Oh, cost.
Cost in this.
Here also. Petitioner will be subject to payment of cost of ₹1,000. Petitioner will appear for the tribunal on
23/1.
January, Lordship.
So this woman has to pay 1,000 extra. You borrow from your
My lord,
husband, take care from her
Next
husband.
time, my lord, only all the cases are will be, my lord, husband, wife, and children should be tried in a one case, my lord. If there are 3 cases, it should be.
Let it come out, we'll see, as in we can't.
Lordship, they don't give the complete details in the
Yes,
WS.
we don't know, the husband may be Indian, may be a foreigner, then they may go to America, have a children, we don't know. This citizenship is not very easy.
Lordship,
You
interesting.
may claim, the parents, the child is born in America, then he will claim I have born citizen.
WS
So,
or in the
yes.
report, they will never say who their father.
yes,
First of
okay,
Only in this high court, they'll come and clap petition saying that this is my brother or sister.
yes.
Item number 7.
Monique Kormukar, 2019.
My
what is
lord,
this?
in this case, my name is not shown in the cause list, my lord.
Okay, very
Lordship,
good.
in this case, notice may go, I mean.
Actually, notice has not been issued.
No,
No, my
Lordship.
lord.
Notice record interim. And Mr.
PCD.
PCD.
My lord, my name is should be shown in the cause list.
Now, this is again by showing the name of Mr. PCD, counsel for the petitioner. Yes, next.
Item number 8.
Zahra Khatun.
May I please also? Here is a case, lordship, in this case, the petitioner, brother is adduced evidence. Gamra adduced evidence.
Yes,
And in
Dharma,
the opinion, nothing discussed.
brother, elder brother or younger brother?
Then
No,
as
brother.
stated, my friend was supposed to place before this court, some order of this high court pertaining to this.
Oh, yes, yes,
If
yes,
he has
yes.
brought it, Lordship. Notice has not been, Lordship, it's a new matter, so at this
That-
stage,
that-
notice may go.
Initially, the petitioner was declared for Indian lordship. But surprisingly, in the order set, in the separate set, the opinion is not found, lordship. That's a sole motor case is there. And the matter is remand back at the hearing stage, lordship. And with, after taking this, without considering evidence, opinions past.
Okay, notice record interim. So,
Deeply obliged.
Abdul
Number nine.
Malik, Abdul Malik.
Yeah, this is a contested matter, my lord. Lordship will find impugned order as page 40,
Hmm,
by which my lord the petitioner has been declared
hmm.
winner. Although my lord petitioner has exhibited as many as 10 documents. But on list of 1970. And
70.
70 of his father. And but on list of 1985. Along with his father, the petitioner's name has even appeared.
In 1970, 1970.
70 his father's name and grandfather's name. And 85, the petitioner's name is appeared along with his father. That was not
Okay, then
considered.
we'll examine.
Examine lordship.
Notice record interim.
Interim, my lord.
Yes.
Item number 10.
Kokon Rakshit.
Please, Lord.
Kokon
This matter,
Rakshit.
Lordship,
Kokon Rakshit, you are Rakshit.
Rakshit.
I have not heard this name. Huh?
But see, this matter also, my younger brother, he declared Indian. The same time, same year, Lordship reference was made. Lord.
Huh? Sorry?
Year 1999, same time, two reference, Lordship, against my younger brother. He declared at that
Okay.
time Indian. Lord.
Examine
Now,
lordship.
2016, the foreigner.
What is your name?
Kukon Rukshit, Lord. AU Ahmed.
AU?
Ahmed.
Yes,
Examine
notice
lordship.
record interim.
Item number 11.
Fatima Begum. Yes,
May I please lordship?
yes.
Lordship, the father and mother's parents of name is recorded in the 1966 and 1970 voter list, lordship. And the forefathers of the petitioner was originally from Kasar districts and they migrated to Nagaur, Huzai district, lordship. And that's why the confusion.
Examine.
Notice record interim. Yes.
Deeply obliged, lordship.
Item 12.
Ashraf.
My lord, contested case, my lord. In this case, my lord, mother of the petitioner was examined.
Examine.
Notice record interim.
Item number 13.
My lord, here the elder brother and Gabor has been examined. And my name also appeared along with my father in the voter list of 2005.
Notice record interim.
Item number 14.
Majid Ali.
My lord, here in this case, my lord, mother was examined and mother facing a proceeding declared not foreigner.
Oh,
Mother-
mother is now Indian.
My lord.
Oh, yes.
Examine lordship.
Notice record interim.
Item number 15.
Ayesha.
May please, your lordship. Your lordship, in this case, the name of the grandfather of the petitioner was enlisted in voter list of 1966, his father in 1971, your lordship. Also, the elder brother of the petitioner has been
Notice record interim.
obliged, your lordship.
Item number 16.
Akhtar Ali, yes.
My lord, here the Gabor was examined, my lord.
No.
And my lord, initially, my lord, he was declared the foreigner. Thereafter, the challenge before the honorable court. The honorable court, my lord, set aside the judgment and remand back. And on the basis of the Jamabandi, my lord, it was directed to hearing properly. And this time also, my lord, the learned member, my lord, did not consider that Jamabandi copy,
Oh.
which I have, my lord.
Examine.
Notice record interim, yes.
I am obliged.
Item number 17.
Faisal.
Your lordship, in this matter, your lordship, what happened, the petitioner could not produce the voter list because his name was declared doubtful. And to prove his linkage, he produced exhibited admit card of HSLC, but the tribunal discarded.
Admit card of?
HSLC examination, your lordship.
Notice lordship.
Notice record interim.
Item number 18.
Biola.
My lord, the proceeding's name is in the voter list of 1966. My lord.
66.
Yes, my lord. Lordship may
Notice
kindly.
record interim.
For admission, item number 19.
What is this Jalaluddin? What is this?
My lord, his father, the petitioner's father was declared.
Why
as
it
a-
is this admission? We admit.
My lord, LCR
Oh,
not
yes,
received, my
yes,
lord,
yes.
since 2019.
LCR has been called. LCR is there, Jalaluddin. Huh? Code, no, not yet received. Oh, okay.
Reminder maybe.
LCR has not been received, registry to send a reminder again. Yes,
Item number 22.
Ashraf Ali.
My lord, in this case, my lord, the LBS report does not say that he.
Anyway, today with records have come
My
in
lord.
here, since the records have been received, the matter will be disturbed for hearing. Yes, Nick,
Obliged.
Item 23.
same also. What is this IA? IA is for what?
I has become infectious, my lord.
Okay, Likho, the show has become, going to send close. And main में लिखो, since the records have been received, the matter will be disturbed for hearing.
Obliged.
For orders, item 25.
Yes, my lord, the record has come, the matter will come up for hearing.
Yes, since the records, because since the records have been received, the matter will be disturbed for hearing.
Item number 26.
Hello, Nandi.
May I please, your lordship? Lordship, I'm appearing on behalf of my senior, Mr. P.N. Chaudhary. He is not being able to be present here today because he's out of station. In the last occasion, my lord, we were required to file an IA amending the prayers of the review petition, and accordingly, we have filed an IA.
You have
So
filed.
that IA may be allowed. And
Yes, I have got a copy of the IA. I also know this. Have you, when did you file the IA?
2nd of December, my lord.
2nd of December. Okay, list along with the IA. Do you have the IA number?
Yes, my lord.
Yes.
3654 of
Okay,
2022.
list this along with IA number
3654 of 22.
22 next week. Huh? So then we'll allow that IA. Yes, next.
Obliged.
21. 21,
Yes.
12. Item number 27.
My please, lordship. Lordship for restoration, lordship. Main case was dismissed, lordship, for non-prosecution.
By whom? By whom? Dismissed by whom?
This is by this honorable court, lordship.
This court. Why you did not appear?
Lordship, the engaged counsel was not well. He's on bedridden situation, lordship. He's in
Oh.
hospital, lordship, and medical
Oh.
reports are enclosed.
Yes, yes, Verma.
Matter may be.
Okay.
Now, Lordship.
I miss case, which is miss case number 11.
11 of 2020.
Okay, Mr. What is your name?
MH Soika, lordship.
And also Miss Verma for the state. The present application has been filed for recalling the order dated 16/5/2019 by which the writ petition WPC number 4989 of 2000 was dismissed for default due to non-appearance of the counsel of the petition. It has been submitted at that order during the relevant period. The counsel for the petition was undergoing treatment. Treatment. What kind of treatment is this? Treatment relating to what?
Lordship, it is relating to kidney and prostate gland, lordship.
Relating to kidney and the prostate gland, and in connection with the certificate, medical certificate annexed with petition. Ms. Verma, considering the aforesaid condition of the client, counsel for the petitioner has raised no serious objection. We also view that if the counsel was suffering from illness, the litigant may not be put into disadvantaged position. Under the second, we allow this application, recalling the order dated
16/5/2019, lordship.
and accordingly restored the petition to file at the stage when it was dismissed. Full stop. I allowed. Main में लिखो
Main matter.
main में in main में लिखना in view of the order passed by this court in this case number so and so, the petition is restored for further consideration.
A copy of this writ petition may be served on us, Lordship.
Which petition?
This 4989, where this IA has been filed.
489. Okay. You give a copy.
Lordship.
Copy of the writ petition be additional extra copy of writ petition be furnished to Lana Council for the
Lordship.
state.
My privilege, Lordship.
Lordship.
Item number.
Item number 28.
Please, your lordship.
Ahmad Ali, yes.
Lordship, this is also a restoration petition. Your
Why do you
Your
are?
lordship, actually, we were the newly engaged counsel, your lordship.
And then
And your lordship, so in the cost list, your lordship, there were a lot of counsels, your lordship, so somewhere we missed out. And further, this case was listed in the part 2 list, your lordship. So in many occasions, it didn't reach, your lordship. So on one occasion,
IA.
yes, your lordship.
It
Yeah.
remained unrepresented on 3 occasions. That is why it was dismissed, Lordship.
Once, your lordship,
Force has to be imposed on the council or the party.
Party lordship. because
Party, what, why should a party suffer for the fault of the council?
No, your lordship,
Because the councils, there were about 4 or 5 councils, lordship will look into the audit.
So why should the party suffer for negligence of the council?
The, my friend.
Yes, what is your name?
has
I Hussein.
Matters.
Lordship,
But warning, next time we'll start
Yes,
imposing
lordship.
costs on the council.
Council's name
Ah,
appeared.
actually.
Why should
three-
the poor litigant suffer?
Your lordship, 3-4 councils doesn't exist. They had given up the file, your lordship. We were the newly engaged.
But
council.
warning, next time we'll impose 1 lakh on the council. And we'll send a copy to income tax department. Okay. Likho har Mr. Lane Council, also Lane Council. The present application has been filed for recalling the order dated
16/8/2022.
passed by this court, dismissing the petition on account of default for non-appearance of the petitioner. Petitioner, it has been submitted that on the day when it was listed, the council had the matter escaped notice of the council, and it was not deliberate. First off, we also view that the litigant should be placed to a disadvantaged position because of any default or negligence on the part of the council. Accordingly, we allow this application by recalling the order dated so and so, and restore the file in the petition so and so in the stage where it was dismissed for further consideration. Then Liko in terms, mainly Liko in terms of the passed by this court in so and so, the matter is restored for, this is for what stage? What was
Hearings.
restored? File was restored for and we listed at the stage where it was when it was dismissed.
Your lordship, the interim order passed earlier may also be restored.
So since upon restoration of the petition, the early interim order pass on
22/12/2016.
shall stand revived.
Item number 29.
Asmat Ali.
Look, in this case, lordship, after obtaining of bail, lordship, petitioner went to bail bond for SP Dorong. Thus, SP Dorong did not allow his bail bond and sent a letter to SP Udalguri in page number 14, lordship. And accordingly, the letter was sent to our senior Mr. H. Lordship, in page number 14, lordship.
Now, what is to be done? Tell us.
Lordship, page number 14.
Okay. The present application is filed for seeking clarification from the direction to the SP border Udalguri for accepting the bail bond and the surety in terms of the order passed by this court on 30/6/2022. It has been submitted. Is there any defect in this order? No. It has been submitted that there is no defect or ambiguity in the order, and as such, non-acceptance by the SP border Dorang.
As the records are with Udalguri lordship.
And on the ground that the records are with SP
Udalguri lordship.
SPB Budalguri may not be proper. We are also the view that this is an administrative issue which may be sorted out among the concerned authorities. Let it be done. Till then, the petitioner shall not be put to any, the petitioner shall not be subject to any coercive action. And as and when coercion and may be allowed to execute the bail bond and the surety bond as directed by this court on 30/6/2022. With the above observation, the present I stand disposed of.
Obliged, sir.
Item number 30.
Sohrab.
Yes, lordship, here the name was wrongly typed due to typographical mistake. There was a mistake in typing the name in the petition and the.
Your mistake.
Yes, lordship, that was mistake on my part.
So how much fine you want to pay? 50 lakhs, 50,000, 1 lakh, what, how much? Because your mistake, not the client mistake, not Sohrab Ali's mistake, your mistake.
Yes, Lordship. It
Then
is
you'll
my
pay
mistake.
some fine or no?
That was an unintentional typographical mistake only.
Then who your typist will pay or you will pay, tell us.
I'll have to pay.
Huh?
I'll have to.
You have to pay. Anyway, this time is exempted. Next time we'll impose 1 lakh. The present application is filed for correcting a typographical mistake which is kept in the pleadings. It has been submitted that while describing the particulars to the writ petitioner, it has been wrongly typed as what?
Saurabh, SAURAB.
Oh, paragraph 6 है ना, लिखो whatever है ना. So it has been submitted since the mistake was unintentional. The petitioner may be allowed to be correct the description of the petitioner by entering the correct description. The prayer being not objected is allowed. So and so on. Accordingly, necessary corrections may be made in the main writ petition.
And in the order sheet.
First off, this order passed today may be read along with the earlier orders passed in this petition for clarification of the identity of the petitioner. I had disposed of. In the main manner, necessary correction is correction is allowed to be made in terms of the pass in IA number so and so. You make the correction.
Yes.
Council is allowed to make the correction by hand.
Item number 31.
Lal Bhanu.
Why not praying for some more time to appear before the superintendent?
Why it didn't know?
Initially, in terms of the earlier order, as protected by your lordship, I appear before the SP and every formality has been done. Subsequently, lordship on 6/9/2022, again the matter was listed. My friend lordship, my colleague lordship, prayed for adjournment, but the honorable court has lordship passed some order that was not within his knowledge. Again directed to appear before the superintendent of police.
So then you appear again. What's the problem?
That time bound was given 21/9/2022. That time has expired. lordship.
Our Mr. Lane Council has to Lane Council clarification. The present application for file for extending the time for appearing before the SP border.
Dhubri lordship.
Dhubri, in terms of the order dated.
In 6/9/2022.
So the prayer is allowed, not being objected. Petitioner may again accordingly appear before the SP border. Dhubri is directed by this court again within a period of
15 days.
15 days from today. I disposed.
Mass of lordship.
Item number 22.
What is this?
Please, your lordship. I just want the voter IDs of my father, mother, my brother, and the neighbors, because neighbors are quarreling with me because my neighbors are fighting and quarreling with me on the ground that their voter ID cards are exhibited and not returned back.
Yeah,
Neighbors
yeah.
has adduced evidence, and those all.
Lordship had already passed a similar order the other day. The registry will examine, she'll give a copy of the same.
Oh, you want to get
Voter IDs.
See the voter IDs of people who had appeared as DW.
you have a copy of that order? No.
Yes, we have no objection to that, lordship.
The present application has been filed for allowing the petitioner to take back the original documents
From the registry.
from
We have
filed before a tribunal, and since the records are now before the records are in the having requisition, necessary direction may be issued to registry to collect those original documents. Full stop. It has been submitted that these original documents will be required for what purpose?
Voter ID of my father, they required for their personal use.
Okay. these
Everywhere
documents-
voter
okay,
ID is
these-
required.
These documents will be required for the day-to-day personal use of the petitioners. Accordingly, since the prayer had not been objected the prayer is allowed. The petitioner may be allowed to collect the original document, however, scan copy or photocopy?
Not documents, only the voter IDs. I have
Okay,
prayed only for the voter IDs.
Only voter ID, huh?
Yes, voter
Okay,
ID.
so
of my
the-
father.
A copy of the voter ID, photostat copy of the voter ID duly certified.
So the registry will examine it itself and keep a copy, Lordship.
Okay, the registry will furnish the voter ID and retain a copy of the same after comparing with the original and the certifying that this is a certifying to the effect. With the above observation, the present
The epic of the father, mother, brother, and neighbor.
Yes,
Because there are
Lordship.
4 of them.
neighbor also.
Yes, neighbors. Neighbor is only fighting. Father, mother, they can understand. Daughter is declared as foreigner, but neighbors also adduced evidence. 2 neighbors has.
Now neighbor is angry with you.
Yes, yes, always fighting.
Next
with me.
time he said they are foreigners. I don't want to help them. Huh?
Yes,
Next proceeding, they are not going to cooperate with you.
Yes.
Huh? They will not come also.
In
They will
a
say that they are
one
foreigners.
ruler, They will be scared to adduce evidence
Okay.
because they keep the originals.
Item 1.
Yes, Board Pathor.
In this case, we have filed this review petition on the ground that while the labor code has directed us to pay some back wages
Yes.
till the claiming that the from till 2007 lordship. But our case is that he was as per their admission that he will be retired on 1998. Lordship, in evidence in the learned labor before the learned labor code, he has stated his age as 68 years, and he has admitted that the attainment of last superannuation period is still 58 lordship.
Sorry, please come back again. What was the order which is sought to be reviewed? Let us see the order. Let us see the order which is sought to be reviewed.
Lordship, page it's start from page 14 lordship.
Page 14.
Yes, lordship.
Now, so and so,
Unfortunately, on that date, lordship, learned counsel, the petitioner was not in present. Lordship.
non appears to the petitioner.
Yes.
On several occasions, the petitioner failed to appear, hence they made it an absence of the petitioner.
There is some communication gaps we have stated in this review.
The
petition.
present file again order passed on learned labor council, by which the labor code had directed payment certain due amount on account of wages and other entitlement along with interest on culmination of a long drawn legal and judicial proceeding after he was dismissed from serving in 1985. The relevant portion of imperial power because of what has been discussed and analyzed above, I am of the opinion that the petition filed by the Ranjit Dattachari is allowable with certain modifications in the accounts he has made. According to the petition is allowed on the contest in the opposing party management is directed to pay the petitioner Sri Ranjit the amount which should come out after deducting the amount they have already paid under section 17B Act and along with from rupees 7 lakh who repaid under from 7 lakh 52. 7 lakh 52 means this was already awarded or what?
Yes, lordship.
7 lakh 52 was already awarded.
Yes.
Then what was the direction of the tribunal?
7 lakh 52. That was the amount.
Sorry, I can't hear you. Please, Press it.
Labor code has directed to pay 7,52,146 along
So,
with a simple interest of 12%.
so
So
you are
our-
agreed
our-
by that.
Yes, but our case is that it is since we have filed several petitions and subsequently it was going to Supreme Court also, we have paid. Therefore,
We have
the-
only
the-
paid 7 lakh.
the workman is.
Huh?
Paid.
You have, huh?
No, nothing.
No, this, see, is directed to pay the petitioner Sri Ranjit Datta Chaudhary the amount which will come out after deducting the amount they have already paid under section 17 Dispute Act from 7 lakh 52,000 along with simple interest. So you are entitled to 7 lakh 52,000 or more.
That is as part of award, my lord, but they have not paid anything, my lord,
Huh.
because my lord.
The petitioner was serving clerical post, transferred to so and so. How the authority proceed against a non-common transfer account dismissed. The conciliation officer recommended, awarded reinstatement, awarded challenge, dismissed by the court, appeal. In the result, the reinstatement is attained finality. During the penalty, the private respondent reached the age of superannuation. NSS issue of reinstatement service did not arise, but he was entitled all the benefits to post into retirement. It is this monetary benefit under benefits which are work and so conciliation held to advise the government to approach the proposal. In that connection, the Lanet Labor Code will pass the impugn order directing to pay the worker an amount of the amount after deducting the amount which they have already paid under section so and so or rupees so and so along with it. Lanet Council Government has submitted a challenge in this is totally misconstrued for reason the scope of we only to assume whether award passed by this was or not, or whether in which suffers from definition or whether in this regard has and Council Government has referred the decision side so and so. Lanet Council has following decisions. Raised is whether suffers from. It also has failed to appreciate. It is also alleged that Lanet Tribunal failed to appreciate evidence adduced by management, failed to observe low adjudications and so on. Before conducting around, like to make this court is not sitting as appellate court to examine the current stand of the this court has to examine whether stand and so on. It is seen the Lanet has raised from the it is seen the Lanet has learned finding facts that pertain to and so parliament and challenge. As a facts earlier proceeding more than the award dated past the Lanet challenge. Which was had resulted in failure and attempt service. And so this court so noted the Lanet Labor Court while deciding matter had the evidence of parties. According to the view that held the other person is not based on evidence in neither court find them to be rational human. And so one right is imposed 50,000 in the not paid instances. Now, how do you, on what ground you want the review of this?
The review of application since the Labor Court has already directed to 7 lakhs. Regarding, we are not disputing his settlement, but we are disputing only that Labor Court has directed us to pay 7 lakhs, holding that he is he will be superannuated on till 2007, Lordship.
2007.
But our case is that it is admitted fact that he will be superannuated on 1990 as per his own admission till 1990.
From why we get all those documents?
Lordship, in 1988, the writ petition which has been filed in the year 2010, where Lordship, the order.
See, its latest is 5561 of 2010.
Yes, sir.
Now, in this 5567 of 2010.
Yes, but page 32, Lordship.
Page 32. Cross-examination of PW and Ranjit Datta. Before working, I had also worked in Havas and so.
Page 33, Lordship.
Page 33. I attended NFC in 1998 as per matrix, but in our time there was no provision for student and one can go on from working on making 40 years.
Yes, Lordship, that means Lordship, he will be superannuated in the year 1998. Lordship, again, Lordship, kindly come to page 34, Lordship. This is evidence on affidavit of PW2, Lordship. This is a review application, my lord. Therefore, the review of application, but on that, Lordship, apparently that the council was not there for the management side. So we are only.
Evidence on affidavit of Bijoy Borthakur. Who is Bijoy Borthakur?
PW2.
No, who is he? Who is he? He is the Secretary Golaghat Circle.
Yes.
Sangha.
He is the union.
In your favor.
He is their favor, Lord.
I mean, yes, in favor of the workmen. What did he say?
Page 35, Lordship.
What did he say? Yes.
The economic express that at the relevant time when Sri Ranjit Datta was appointed, there is an understanding between the employer and employee that a workman can discharge service for a period not more than 30 years or 58 years of age, whichever is earlier, but subsequently with effect from 1/11/97, condition of 30 years of service had been withdrawn and only attainment of 50 years age has been fixed for retirement. So one hand, Lordship, the Ranjit Borthakur.
So according to you,
yes,
he will retire on reaching the
1998. As per our record, though 94, but admitting.
He said 58 years, no?
Yes.
58 years will be when?
1998.
1998. 8, not in 2007.
Not.
So 2007 means 19, how many, 1998, 2007 means how many, 9 years,
9 years.
9 years difference. So you mean to say that the labor code has wrongly given 9 years salary,
Yes.
additional salary? Huh?
And-
Is it your case?
Yes, Lord.
Huh?
Yes, Lord. But learned labor code while appreciating the on the basis of the calculation submitted by the
Why is
workman,
the calculation of the land and labor code?
it start from page 36, Lord.
Page 36. Well, how do you say that the labor code calculation is based on that 2007, not 1998, according to you? What is that calculation?
Page 41, Lordship.
Page 41, yes.
Para 12, Lordship. Now
Para,
first,
para, para.
para 12, Lordship.
Para 12. Para 12.
Now first.
Page 43. That the workman is not, no, no.
41.
Page 41 is the evidence in chief of Harsh Sutudia
Lordship, in review petition, Lordship.
in the review petitions. Page 41.
Yes.
Page 41, para number.
Para 12, it start from.
Now, first question is whether in the garden of opposite party in the superannuation age was 50 years or whether the person worked in the garden 40 years while the petitioner first entered service. It is both sides admitted fact that the petitioner entered service in 1968. Huh?
Yes.
And his service was confirmed from 1/4/1970 and he was dismissed for service from 1985. Now question is that what was the superannuation age of 1970? That is in the year when the petition was made permanent. The petitioner, by filing statement of his entitlement along with the financial claim that his pay went up to 22/27, the petitioner joined service in the year 1970 and his service confirmed. And the petitioner submits that at the time of joining the petitioner convention was who can work in the garden for up to 40 years. He further submits the exhibit retired so is enforceable from he submits the exhibit A notification is enforceable and this notification is applicable to workmen who joined in the year 1970. I have preliminary when it is found that notification come to form 1970, thus it is applicable to case workmen who joined the service on or after 1970 and this notification is not applicable to the petitioner. In this case, the opposite party side fails to produce a document about retirement age prior to 1917, nor adduce any oral evidence as to the age of superannuation by workmen prior to 1917. In such circumstances, it must be presumed that the says true. He said while he joined service, the convention was the one, but so it is proved that a workman who had joined service before can work with a maximum of 40 years of age. That being the case, that convention is applicable and the notification is not applicable. So I hold the petitioner entitled to work for 40 years maximum. The petitioner says that he joined in the Tribunal 1941 and hence he worked from 1908. In the statement, he calculates from the dismissal to having some so. So I hold the calculation so is correct calculation so.
So on the basis of the logic, the said paragraph, mere paragraph of the said paragraph makes the discernible that on the basis of the calculation made by workmen, the learned labor code has held it.
Yes.
But the evidence which has been I have now placed before your lordship, page 32. It's his own statement, lordship. Paragraph 33, lordship. I
attend the students in 1998 for matrix, but then in that one can go on, no?
So lordship, he has himself admitted, lordship.
That the deponent begs to say the relevant time when Ranjit Dotto was appointed, there is an understanding between the employer and the employee that a workman can discharge service for to more 30 years or whichever earlier, but subsequently with effect from 1/1/1970, condition of 30 years have been withdrawn with effect from 1/1/1970.
Yes, sir.
The condition of 30 years service have been withdrawn and only a term of 50 have been fixed for retirement. Correct? What is this 1/1/1970?
Otherwise also, lordship,
No, just a minute.
he entered in the year, his service was confirmed. As
He entered in the year?
in the year 68, what lordship
No.
said was confirmed in the year
When he entered, Tariq?
in the year 1968, Lordship. It's only, and his service was confirmed with effect from 1/4/1970
The service
was confirmed.
1968.
Yes, Lordship, but his service was
Confirmed with effect from
1/4/1970.
with effect from 1/4/1970. But then this notification came with effect from 1/11 after he was confirmed. So what is important? What was the law on 1/4/1970?
Then 30 years, Lordship.
Huh?
That 30 years,
30 years.
30 years.
And then 30 years means if you enter service in 1968, 68 plus 30 years, how much it come to? 8. 8, then 9. 1998.
Yes, sir.
Yes.
So our case, only case is there. Lordship.
You
I-
say that
we
you
are-
are
we
entitled
are-
to 30 years or 50 years or whichever is earlier.
We are not disputing that he is entitled. Lordship.
What to do with this? Your evidence said that suppose you entered service in 1968, and then you are confirmed with effect from 1970. At that time, the deponent begs to state that Bijoy Borthakur. And there is an understanding between the employer and the employee that a workman can discharge service for a period of not more than 30 years or 50 years, whichever is earlier. But subsequently, it was but then that will not apply. After what will happen after 1/11/1970 will not be applicable. But so 30 years, if you have 30 years, if you have joined in 1968, 30 years will be 1998. What do you say? Because that will be error apparent on the record of the case, no? Because the decision cannot be based on wrong facts.
My lord, my submission is that, my lord, the workman was dismissed in 1985. Since long, then, my lord, 21/9/85.
21 dismissed on
21/9/85.
1985.
Yes.
Yes, correct.
Thereafter, first award is in 13/9/90.
Sorry, award.
Yes, in 90. First award in favor of the workman, my lord, directing him to resign.
First award is
13/9/90.
13/9/1990.
90. Yes. Thereafter, they came before your lordship, my lord. It was remanded.
And first award maybe that was upheld by the Supreme Court award.
No, they came before your lordship, my lord, and it was again in favor of workman, my lord. Therefore, my lord, there is again, it was remanded to tribunal, my lord, for trace decision. And that is also in favor of workmen, my lord. That is second award in 31/12/98.
Second award is
31/12/98.
31/12/1998.
Against that, my lord, management came before writ application that was dismissed. They filed writ appeal that was dismissed, my lord. And thereafter, my lord, we filed this application, my lord, for calculation of our dues, my lord. And
So calculation, earlier award did not mention the specific calculation. Earlier award mentioned what is, let us see the second award. Do you have the copy of the second award? Where is it mentioned? 1998. Do you have a copy of the second award, which was upheld by the Supreme Court?
Not by Supreme Court, my lord, writ appeal.
Writ appeal. What is that? What is the order of the, what is the award? Copy of the award? Just there in the it's a page number.
Lordship, it is annexed with writ appeal, Lordship. Earlier writ appeal. Writ appeal of 2007, Lordship.
What is that? So earlier direction accordingly consider all aspects The matter dismissed set aside, the workman is reinstated to the post held by him with full back wages and all other services. Now, what is that full back wages? It was not determined.
Yes.
So it was supposed to be determined, and this was determined by this labor court, which is
Yes.
being challenged.
That is sellers.
Correct. If that is so, while determining, obviously, he has to be given what he is supposed to get. And you cannot get more than what is you are supposed to get. How much you will get?
That is the calculation, my lord, as per
So
calculation.
what is, they say that he should retire in 1998, not in 2007. Then how do you say that you retire in 2007? How this was given?
The finding of the.
Maximum period 40 years. Now earlier is 40. Now from where you get this 40 years? See, if it is 40 years, it will be 2007.
2007,
If it is 30 years, it will be 1998, isn't it?
1998.
So how, from where this tribunal gets this 40 years? The conventional rule was that a workman can work for a maximum of period of 40 years. From where you got this? Where is the evidence? Where is the convention?
Finding of the, my lord, trial court is as base 45, my lord. That is operative portion, paragraph 20.
No, correct. Finding is 7 lakh
Because
52.
of what has been discussed and analyzed above, I am of opinion that the petition filed by the petitioner.
No, we have agreed, we have read it, but then this amount is based on certain criteria.
Yes.
Now, if it is 40 years, maybe it is correct, 7 lakh 52. If it is 30 years, then it will come down because he will retire on 1998.
Again, my lord, I may submit, my lord. The workman concern expired, my lord. On 4/1/2021, we have filed an application, my
Or
lord.
one?
4/1/2021.
Huh.
We have filed an application, my lord, for substituting his.
Anyway, that is.
Therefore, my lord, on that, my lord, your lordship pass an order on 27/7/2022. Your lordship may peruse that order, my lord.
And what is that one? 20?
27 July 2022 in the substitution petition.
Only one petition.
In substitution petition. madam.
I don't know, this 29/6/2022. It's contested.
In review, it is passed in review petition, my lord.
No, what do you want to say? What do you say? What was the order?
And that was, that is, my lord. In view of long pendency of the review petition, and as the workman has not been paid a single paisa out of 7,52,146, along with the interest as directed by the labor court, and the review petitioner has admitted to the liability for the period from 1985 to.
No, but if you this 5 lakh, will you be satisfied with this 5 lakhs?
Yes, my lord.
Another aspect, lordship,
Mister, then let us no go for this. Yeah, you see, 5 lakhs, you want that we can close with this 5 lakhs?
Yes, my lord.
Instead of 2 lakhs, 7 lakhs, come to 2 lakhs, what is this? No, earlier is
lordship, as per our calculation, lordship,
7 lakh 52.
as per
So settle with 5 lakhs, finish it off.
as per management's instruction, lordship, he is entitled for 2,92,196.
Oh, Mister, what person has died, he has gone to so much of trauma. See, you are only thinks of, khata, bohi khata. Credit, debit. You don't see the credit, debit of the human being's life, which is,
Lordship, as per my instruction already, as per honorable court's order.
we'll close this with this, we'll confirm, we'll allow the revision, but then we'll allow one, but we affirm 27/7, 5 lakhs, you close it.
One-
You are,
1 lakh already paid, lordship.
doesn't matter, you pay this 5 lakhs, we'll close it without going to. At this stage, to go, a person has died,
Widow is also.
widow is there.
Lordship, only record that whatever already paid, lordship, that may be deducted. Because as per my instruction, already 1 lakh paid, lordship, as per lordship's order, lordship.
1 lakh has been paid, my lord, in the time of admission of the retable, my lord. Cost has been by.
That is paid, lordship.
That is.
Dekho, her mister,
K Kolika, lordship.
counsel, but her also means what Jajilan. The review petition has been filed seeking review of the order dated What is the order of the court order?
Order 10/12/2018.
10/12/2018 passed by this court in
18,
WPC number 556 of 2021, or by which this court, after considering the materials on record, directed that the petitioner that the management should release the amount of rupees, should release the amount as directed to be paid by the Labour Court of Assam with interest of Assam, and also impose a cost of 50,000 on the management. It was also directed that if the amount directed to be released paid by the Labour Court in terms of order dated 30/7/2020 was not released forthwith, it will carry additional interest at the rate of 18% per annum on the due amount. The aforesaid order is sought to be reviewed primarily on the ground that the said order was passed in absence of the learned counsel for the petitioner. And as such, certain important facts could not be brought to the notice of the court, which would make a good ground for review. It has been submitted that the order of the Labour Court was based on the premise, order of the Labour Court directing payment of rupees. See, how much is that?
7,52,146.
146. Was based on the premise that the petitioner, the workman would be entitled to serve for 40 years. Though, as per the records and as per his own admission, he cannot serve more than 30 years. And as such, the learned Labour Court had made an error by directing payment for additional 10 years of service, which was contrary to the record. And as such, it has been submitted that this order passed by this court on 10/12/2018 in WPC number 5561 of 2021 may be reviewed by reducing the quantum of arrears of salary which is liable to be paid. It has been submitted as if the amount is calculated on the basis of 30 years of service, which he is entitled, the workman entitled to, it will come much less than 7 lakh, 2 lakh, 7 lakh.
2,92,197.
It will come much less than 7,50,000 and the 146, and it will come to merely 2 lakhs
92,197.78.
And accordingly, it has been submitted that the order may be recalled. Next. Ms. Bhattacharya, however, on the other hand, submits that the petitioners are to be blamed for not appearing before the court as clearly reflected in the order dated 10/12/2018, in which it is clearly mentioned that on earlier several occasions also, the management did not appear before the court, which compelled this court to pass the order in absence of the counsel of the petitioner, and also considering the fact that the matter has been pending since the matter relating to payment of areas of salary have been pending since several litigation since earlier first claim you made.
It is 90, vendor.
19?
39, 90, vendor.
39?
90.
90. 13?
The first award is 3990, my lord.
3990.
90.
Full
First
stop.
award.
What? In this regard, Ms. Bhattacharya has submitted that in connection with regard to the said dispute about payment of arrears, the first award was made by the Labour Court on
13/9/1990.
1990. And as I said, award was interfered by this court. The matter was directed to be redetermined by the Labor Court. And according to Labor Court, made the second award on 31/12/1998. The challenge to such award was also unsuccessful. The challenge to the award, the second award by the Labor Court, was also by the management at this court as well as before the Apex Court. Was unsuccessful, and ultimately this writ petition full stop. Review full stop. And accordingly, no. After the second was made, then this
Case 34.
no, this page 14. This writ petition was filed against what? 5561 of 2010.
Page 34 Lordship.
No, this.
The-
No, WPC number 5161 of 2010 was filed against what?
Against the award dated 37/2010, passed in miss case number page 34. Lordship. Page 34 of review petition.
Page 34. No, WPC number 5561 was passed against what?
Against the
Okay.
judgment dated 10/12/2018.
Okay. Subsequent to the second award, the Labor Court of Assam determined the amount payable, which the Labor Court fixed at 7,52,146 with simple interest of 12% by calculating the years of service of the workmen to be 40 years. It is this finding by the learned by the Labor Court by them 50 calculated
From
by
21.
in miss case number 1 of 2009. It is this case, this direction issued by the finding of the Labor Court as per judgment dated 37/2010 in miss case number 1 of 2009, which is the subject matter of challenge. It was a subject matter of challenge in WPC number 5561/2010. Full stop. Full stop. It has been submitted that in the during the pendence of this review petition, the workmen also expired on 4/1/2021.
Yes, 4/1/2020.
Leaving behind
Leaving ailing wife and
two sons.
two sons.
These two sons are working on.
They are doing business, but nothing.
Okay, the two sons. And as such, it has been submitted that reviewing the order of this court passed on 10/12/2018 will require undoing, will cause great prejudice to a workman who has already expired and who had not been paid his due salaries since 21/9/1985, when he was dismissed from service.
And
If-
one observation may be there, all along, my lord, each and every order is in his favor. In spite
It
of
also,
that,
yeah,
it's not-
further, in all this proceeding, the tribunal or the court has been, the petitioner, the workman had been getting all the orders passed by the Labor Court, this court as well as Supreme Court has been in favor of the workmen.
Not Supreme Court, my lord, read
Appellate court, sorry, not Supreme Court, Supreme, has been in favor of the workmen, and as such, the reviewing this order at this stage will cause great prejudice to the workmen,
Proceeded to the ailing wife. my lord.
especially the ailing wife who was dependent on the workmen. Next round. Though having heard the learned counsel for the parties, though the plea of the petitioner that since the Labor Court made a mistake, since the Labour Court, while passing the order on 37/2021 in Miss Case 1 of 2009, in directing payment of rupees 7,52,146 was based on a wrong premise that a workman was entitled to work for 40 years. Contrary to the evidence on record that the workman is at best entitled to work for 30 years. This can be a ground for review, yet this court has to keep in mind the various attending circumstances. The fact remains that the workman was dismissed from service on 21/9/1995, and since then he has been running from pillar to post, invoking the various legal forums to get his dues. If the management had given the entitled dues to the workman on 21/9/1995 itself or soon thereafter, the matter would have been otherwise. The workman in his lifetime did not see the benefit, could not enjoy the benefit of his successful legal proceedings initiated by him for getting his dues. In fact, he died on 1/4/19. He died on 4/1/2021 without getting a single penny of the benefit he is entitled to.
And my lord, a copy of this order passed by your lordship, my lord, we have staff under management, they received.
We also have taken into consideration, as also submitted by Ms. Bhattacharjee, that this review petition itself was pending for a long time. Filed in 2019 was pending for a long time and has suffered several adjournments on different accounts. And considering the peculiar nature of the case, this court passed an order on 27/7/2022 directing and keeping into consideration the fact that the workman had not been paid a single naya paisa, had directed payment of rupees 5 lakhs immediately. And since the said workman had expired, the amount may be paid to the legal heirs of the workman. The order passed by this court on 27/7/2022 is reproduced herein below.
Only my submission that the management has already handed over 3 check lordship in our head.
Doesn't matter, whatever you stop. Under the circumstances, keeping the peculiar facts of the circumstances of the case, though the management may have a technical right seeking review of the order passed by this court, keeping the peculiar facts as discussed above, we have the view that the ends of justice will be met if we direct the management to pay, affirm the interim order passed by this court on order passed on 27/7/2022 by affirming the direction to pay rupees 5 lakhs to the workman, to the legal heirs of the workman, as mentioned in the order dated 27/7/22. This court has taken this view, keeping in mind that the workman was deprived of this due since 21/9/1985, during which time the workman had to suffer enormous inconveniences and also hardships of seeking redressal through tortures, legal proceedings, and the hardships caused due to non-payment of a single naya paisa. Under the circumstances, we are inclined to close this review petition with the direction at full stop. Ms. Bhattacharya also has submitted that this matter should be put to an end. And there should be an end to this the long legal saga. And the petitioners will be, and the workman and his family will be satisfied, even if they are given 5 lakhs as proposed by this court on 27/7/2022. Full stop. Accordingly, after hearing the view and considering the peculiar facts as narrated above, this court would close this review petition by modifying the direction of this court passed on 10/12/2018 by directing that the petition that the legal heirs of the workmen, namely
Srimati Ashwana,
Huh?
his wife.
no legal heirs namely 1, 2, 3, workmen namely who is the original workman?
R.D. Chaudhary.
Ranjit Datta Chaudhary, namely wife 1, 2, 3, how many?
3.
3, we paid the 5 lakhs without any delay. If within delay, we pay immediately without any further delay. And how long will pay? Within how much? 5 lakhs you should release.
Lordship may only record that 1 lakh already paid. Lordship. They have also
1 lakh
already
Court, my lord, at the time of
that is all
the appeal, my lord, read appeal.
that is also part of the because as per
don't raise all those things. See, this company.
It is long back.
See, this he has been posing. How much we can impose you 5 lakhs on cost because of non-payment? Tell us. You want this 5 lakhs to be imposed? We'll impose. You go to Supreme Court. I'll give reasons for that. You have not paid this workman since 1985. You expect him to run around? You recover, you give a bill of all the fees which he has paid and expenses. You submit to the management. Management will pay entire legal cost. Will direct. Forget about it. Don't raise those issues. 1995, you have not paid a single naya paisa, and you expect him to go around, run around, and the management is merrily filing cases after cases. Why didn't you?
Within 2 months. Within 2 months.
Within a period of 2 months. We also make it clear that if the management does not pay this 5 lakhs within 2 months, as mentioned above, it shall carry a penal interest of rupees. Penal interest. What is the earlier interest?
12%.
12% on the aforesaid amount. We have observation. With this review petition stands closed. This review petition also shows all the difficulties faced by such workmen who has to run from pillar to post to get their dues, and no, we will not make much observation. That is not good for you. Already we have made enough verbal observation. 1995, we have not paid a single naya paisa. Yes.
For hearing, item number 1 to 13.
Hearing. Mr. Prasad, for hearing.
My lord, there is a bail petition pending, my lord.
Pending.
1.5 years.
1.5 years.
13 years, 6 months in jail, my lord.
COVID started in COVID time.
No, my lord.
After COVID.
In between.
In between.
Last year.
COVID was in between.
COVID also there. COVID also has intervened, no? See, that's why I say no. What happens tomorrow, nobody knows. What to do, Mr. Deputy?
Hearings, perhaps it could not be. Hearing on the appeals, perhaps.
We are continuing the hearing, no? We thought that we may continue hearing, because at this, after almost hearing, what to do? The question is whether we can hear this, we will be able to, and we have not heard Mr. Chaudhary's argument.
They have, in fact, not.
There are 13 appeals, only ours has been concluded.
Concluded?
Our part has been concluded for serial number 1, madam. Mohit Hotay.
Oh, serial number one, only serial number 1.
And there are 12 others.
There are 12 others.
Madam.
Oh, one team, football team, huh? 11 plus 1 extra, all football matches going also. So you all of you together do the same job or what? Huh? Huh? And you are the captain or what? Football team. So they have to submit also.
They have to send. Appeals may not be possible.
He is the vice captain. You are the vice captain. Oh, you haven't told us. Huh? So what to do?
Lordship may consider the bail petition, madam. Lordship on the month of March, Lordship had
Then
heard.
we have to hear, then we have to hear Chaudhary also. Question is whether we can hear within this. I am told that if Christmas holidays, then after that, Christmas holidays will end up to, immediately after Christmas, a view also. See, after Christmas, view will also no follow, no? View holiday also there. But I think it's Christmas holidays up to first.
It's reopening on
First.
second. Second it's open.
Then and on 12 again view holidays.
From 11 to 16. 2023.
11 to 16. After view.
The appeals may be postponed, madam. Lordship may consider the bail, madam.
Lordship is also aware, Lordship.
What
I don't know, Lordship, how long Lordship will
I
be
don't
here.
know. I don't know. They all newspaper are, newspaper reports are hearsay evidence.
No, Lordship,
Huh?
we have seen. other
Whatever is
reports
reported in
also.
newspaper, we don't take into consideration. They are not admissible evidence. If you say
We have seen other recommendations, Lordship, so that is why.
all those newspaper reports are hearsay evidence, not admissible. So we don't discuss inadmissible evidence in the court.
Newspaper,
So,
Lordship.
Let us see after January 1st week, then after the Christmas vacation. First week, then means
Item 1.
Bail is.
bail is only,
Item 1.
Only one bail application.
Only one bail application.
Item 1.
Item 1. IA number 323. In fact, the hearing in this also was over and they were to respond.
Hmm.
It was over on 8/12/2021.
He has relied upon the Supreme Court. decision.
Southern Singh, my lord.
But, Lordship, I
Beyond
think
10 years.
That will help him. He has to wait for another 6 months.
Oh, 6 months. Shall we list after
That will
6
be
months?
No.
Huh?
That is 14 years. I will be considered for remission, my lord. I'll be entitled for conservation.
14 years.
Otherwise, 10 years.
Is of course
Okay,
that-
then at the January 1st, before vacation.
Lordship.
Before, sorry.
Before vacation. They are not fit.
Fifth, there are some other matters, any other date?
9.
9th is okay. with me.
9 Monday.
9th is okay.
9th. But 9th is
Or after the vacation, after the bail vacation, 24th, man.
9 after beginning. 20 only thing is that
24th.
24.
Lordship,
24, okay.
24.
24 is hearing date.
Yes.
Lordship, I have got a, Lordship, I will be in the Aizol bench. If it can be on 25th,
You'll come back on 25th.
I'll come back on 24th.
You'll come on 24th.
I'll come back on 24th. If it can be on 25th.
25th. On joint prayer, the matter will be on 25th
January.
of January.